I'm Gary Venner, Managing Director of IFA Acquisitions, and I'm joined by Alex Cannon, Partner of Herrington Carmichael, where we continue our informative question and answer series under our YouTube channel to provide top tips when selling an IFA business and an insight into the legal processes when buying or selling an IFA business by two industry experts. The title of the next video is coming up on screen now. So Alex, a lot of sellers ask me this question, whether they should actually use their familiar solicitor or whether they should use a specialist solicitor that understands IFA mergers and acquisitions. And I think sometimes there's a fear of using a specialist for fear of high fees, etc. So how would you answer that to a seller that had that dilemma?
Of course. So the first thing I think with any professional advisor is you've got to trust them. You've got to have that relationship with that person, and whether that is somebody who's a long-standing advisor or somebody who's new, that doesn't change.
Yeah.
Naturally, somebody you've known for a long time, that trust is already there. So it takes a while when you're working with a new advisor to build up that rapport and relationship. But inevitably, through a transaction process such as either buying a business or selling one, it's quite intense. It's very specialised, and particularly in the financial services sector, there's a lot of nuances, both in terms of how deals are structured, in terms of the regulatory aspect, in terms of the purchase price and the adjustment characteristics, and also the various different assurances and limitations that you would expect to see, which are quite different to if you were, say, selling a technology business or a retail business. So whilst I think trust is absolutely got to be forefront of your mind when you are picking an advisor, and cost has to be a factor as well, picking a specialist in any sector is always going to produce you the best outcome. In terms of costs, what I would say is, notwithstanding that they might be a specialist and they've got that experience, we don't tend to find that it has an impact in terms of costs. We find where we're working with new clients in terms of fees, we're quite comparable to other M&A lawyers who might be an expert in tech, for example. So it's more about kind of understanding the nuances of your sector rather than saying, we advise on financial services, therefore there is a premium attached to that, and that I guess would apply in any sector. So we always say to clients, actually, if we talk through and understand what your sort of transaction is about, understand you and the nuances associated with that, we can add a lot of value, and actually in terms of cost be quite comparable.
Yeah, and I would definitely agree with that as well. And I think it's making sure you don't make an assumption without going
Absolutely.
to find out. So that's great. So Alex, tell me a little bit about the legal stages in an IFA acquisition, from offer to completion. So could you just tell us what those stages are?
Of course. So following an offer being made, the parties would normally proceed to heads of terms. The heads of terms is really quite a high-level document that sets out effectively the nuts and bolts of the offer. So what they're buying, what they're paying for it, when they're paying it, and giving an outline of the various different structure and sort of assurances that the buyer is going to want. So within the contract, what are they expecting to get from you as the seller? That might involve various sort of warranties and indemnities and covenants and things like that in legal jargon, but it should just give an overview and a flavour as to what actually that transaction will look like. It'll also commit the parties to a period of exclusivity, so the buyer will normally then be given a period, typically around about 3 months, to go and proceed with its due diligence and then progress on to completion of the transaction. Following heads of terms, the buyer will then normally move into its diligence phase. They will, more often than not, start with looking at the sort of regulatory and financial aspects and essentially validating what you've told them already, particularly around on the finances, making sure that your recurring revenues and EBITDA or other metrics are as you've told them, and sort of put those assumptions forward, but also then looking at the regulatory side of things and not only validating what you've told them about the nature of your business and any potential high risk areas that you've advised on, but also then going into looking at your processes, your systems, doing some file reviews, and just getting a real feel for not only the sort of the letter of the compliance law around that, but also the spirit and the culture in which the business has continued to operate. Because I think that ultimately for buyers tends to give them a very good feel or not, is the culture right in terms of how they've addressed compliance and things. Of course, the sort of specifics are important, but if you've got a good culture around compliance and regulatory findings, then generally speaking, that bodes well for the rest of the diligence they'll do.
Sure. And heads of terms can be done quite quickly in the process, I find. And tell me about what is binding and what isn't binding in heads of terms.
Of course, so heads of terms themselves, very little is formally binding, I guess, is the start point for the heads of terms document. Because it's just that expression of intent, actually really only the exclusivity period and potentially confidentiality clause, sort of like a non-disclosure saying you won't talk about the transaction with other parties, is actually binding on the parties. Yes. So you're not really committing to sell or buy, as the case may be. You're not committing to ultimately what those numbers will be in stone, because those are indications. Effectively, these are the basis on which everybody's expecting to conclude the transaction. And as the diligence phase progresses, the buyer will validate and make sure those numbers are still accurate and fair. And of course, the longer a transaction takes, sometimes actually recurring revenues or profit can increase, for example, take on new funds under management as well. So all too often we see as a transaction progresses, the principles of it remaining the same, but the actual numbers increasing slightly because the market has risen over a period of 3 to 6 months whilst the transaction is being concluded. So in terms of the actual binding terms, it's really just granting that buyer the period of exclusivity.
Alex, sometimes I see in the heads of terms there will be a clause that states that if the vendor pulls out from the deal, then there's going to be a penalty to cover some costs for due diligence and solicitors. For instance, say £10,000 as an example. Do you think that's a reasonable clause to have in there?
I wouldn't say it's normal, Gary. We see some buyers use clauses like that, and primarily it's to make sure that the costs they're incurring during the due diligence phase are recovered if a seller terminates discussions at an early stage. Buyers will be engaging lawyers, regulatory consultants and accountants to validate the target business. So if a buyer has no intention of sort of committing resource to it, obviously they're then concerned that from a seller's perspective that they won't be proceeding properly. Conversely though, the buyer wants to know that the seller's committed to the transaction. Yeah. So what they don't want is the seller withdrawing at an early stage after they've incurred those costs and fees. In terms of whether it's reasonable, I think it has to be used appropriately. I think the level needs to be reflect a shared risk approach, because it can send the wrong message. Yeah. It can suggest that actually the sellers don't have that sort of discretion to proceed, and if things come out in due diligence as well, which mean the buyer has to adjust the terms, sellers then feel like they're trapped into a contract which, whilst the heads of terms are not strictly binding, they feel that there's a penalty to effectively exit. Yeah. I think there's questions around sort of enforceability and whether buyers would actually enforce those provisions. I think more often than not, where I've seen them used, they're to focus the mind. And whilst I've worked with a couple of sellers who have accepted those clauses on the face of it, actually when things came down to it, the buyer and them agreed to part ways and they were never enforced. So I think it's about sort of setting the tone rather than intending to actively recover it. That would be my experience. Yeah, that sounds a good explanation of that as well, in my experience. We've talked a lot about different processes today. So in your experience, what are the areas that really slow down the legal process of buying and selling and actually getting to a completion? And what can acquirers or sellers do to actually help to minimise that sort of period of time? So the primary concern around delay, I would say, is probably an inability to put your hands on the right information. So at the beginning of the process, sellers not being able to gather the due diligence information. It's quite a labour-intensive process. I completely get it. It's easy for me to say, just go and get this long list of information. But in reality, if you can do a bit of preparation before you start the transaction process, or even talk to your lawyer before the diligence questionnaire comes out, they will know more often than not what key questions are going to be asked about the shares, who owns them, staff and employees, property, key contracts. Those sorts of things are going to be relevant regardless of who's acquiring the business. Yes. So if you can go away and collate that information at the outset, then that always saves a little bit of time. I think the other one I would say as well is around sort of making sure that you've got the sort of time and availability to do the transaction. You know, we see a lot of advisors who sort of start a transaction and then will go on holiday for a month or something like this over the Christmas period, and that's, you know, I completely get it, but at the same time that can cause a little bit of delay, because by the time you get back you've then got client work and things to do. So if you are going to go through a transaction process, I think just bearing in mind sort of that it is going to take a lot of time. You know, it's dependent on you, particularly if you're the sole advisor shareholder. So.
And we accept that everybody's still got their day job to do.
Of course, yeah.
But it is inevitable. This does need to be done, and in order to actually pursue the process, then it just needs to happen. So,
very much so. Yeah.
Subscribe to our YouTube channel and switch on notifications so that you won't miss our next video in this series of top tips when buying or selling an IFA business, and an insight into the legal processes by two industry experts, me, Gary Venner, MD of one of the UK's largest specialist brokers in IFA Acquisitions, and Alex Cannon, partner from Herrington Carmichael, who are leading commercial lawyers specialising in IFA mergers and acquisitions.